we are going to see Criminal Procedure Code. In previous class, where we have considered how to execute the imprisonment, death sentence, and recover the fine. That is the execution of sentence. That is இதுக்கு முந்தைய வகுப்பில் குற்றவியல் நடைமுறை சட்டத்தில் ஒரு தண்டனையை அபராதமோ அல்லது மரண தண்டனையோ அல்லது சிறை தண்டனை விதித்தால் அதை எவ்வாறு நிறைவேற்றுவதற்கு உண்டான நடைமுறைகள் என்று பார்த்தோம். அதிலே அடுத்து part E of this chapter, execution of sentence, that is the 31 chapter E, suspension, remission, commutation of sentence. So already court awarded the sentence to undergo imprisonment. Whether the execution of sentence can be suspended or it can be reduced, that is the basic things. So if so, a sentence of imprisonment can be reduced, who is the competent authority? Likewise, a sentence of execution can be suspended, then who is the competent authority to suspend the sentence of imprisonment? ஒரு சிறை தண்டனையை நிறுத்தி வைப்பதற்கோ அல்லது அந்த ஏற்கனவே நீதிமன்றம் வழங்கிய சிறை தண்டனை குறைப்பதற்கும் அதிகாரம் உண்டு. அதில் யாருக்கு அந்த அதிகாரம் வழங்கப்பட்டுள்ளது என்பதான் இனி மேற்கொண்டு பார்க்க போகிறோம். ஸோ how to reduce the sentence imposed by the court, by whom it can be reduced, that is the basic things. So ஒரு நீதிமன்றம் விதித்த தண்டனையை நிறுத்தி வைப்பதோ அல்லது குறைப்பதற்கோ என்ன நடைமுறை, அது யார் நிறுத்தி வைக்க முடியும் அல்லது குறைக்க முடியும் என்பதான் கீழ்கண்ட பிரிவுகளில் பார்க்க போகிறோம். Now we are going to see 432. Power to suspend or remit the sentence. குறைத்தல். Where any person who is sentenced to punishment for an offense, ஒரு குற்றத்திற்கு தண்டனை விதிக்கப்பட்ட நபர், when any person has been sentenced to punishment for an offense, ஒரு குற்றத்திற்கு ஒருவருக்கு தண்டனை வழங்கப்படுகிறது. So a court passes a sentence, whatever the sentence, then appropriate government, that is the either state government or central government, that is the appropriate government. So ஒருவருக்கு தண்டனை நீதிமன்றத்தால் வழங்கப்பட்ட பின்விட்டு மாநில அரசோ அல்லது மத்திய அரசோ may at any time without condition or upon any condition. So the state government or central government with condition, it may impose any condition, or without any imposing any condition, what can be done? Which a person sentenced accepts and suspend the execution of his sentence or remit the whole or part of the sentence to which he has been sentenced. So the sentence of execution of sentence can be suspended or remitted the whole or part of the sentence which has been imposed by the court. So ஒரு நீதிமன்றம் விதித்த தண்டனையினை குறைப்பதற்கோ நிறுத்தி வைப்பதற்கோ நிபந்தனையுடன் அல்லது நிபந்தனை இல்லாமலோ மாநில அரசு அல்லது மத்திய அரசு உத்தரவிடலாம். ஸோ த state government or central government are having right to suspend the sentence of imprisonment imposed by the court or remit the sentence of imprisonment imposed by court, which may be without condition or with the condition. The remittance or suspension can be done with the condition or without condition. That is the basic things. So the government is the competent authority to remit or suspend the sentence imposed by the court. ஒரு நீதிமன்றம் விதிக்கும் தண்டனையை நிறுத்தி வைப்பதற்கோ அல்லது அதை குறைப்பதற்கோ மாநில மத்திய அரசுகளுக்கு நிபந்தனை அல்லது நிபந்தனை இல்லாமல் நிறுத்தி வைக்கலாம். That is the basic things. That is the true motto of the government. Without application, the competent, the government, nobody can file an application. That is the 432 subclass 1. ஸோ 431 துணை விதி ஒன்றில் என்ன சொல்லுகிறது என்றால், மாநில அரசே தானாகவே செய்யலாம். The government, without filing any application, it can be done by the government itself. That is the basic thing. Then subsection 2, 432 subsection 2, whenever an application is made to appropriate government for suspension or remission of sentence, so the accused who is convicted or his relative files a petition to the government, either central government or state government. So if he files a petition to remit or suspend the sentence, then the appropriate minor may require the proceeding judge of the court before the conviction is confirmed to state his opinion as to whether application should be granted, refused to grant with his reason for such an opinion. So whenever an application is filed, the state government may get an opinion from the court which convicted him. That is the basic things. So ஒரு தண்டனை பெற்ற நபர் தன்னுடைய தண்டனையை குறைக்கவோ அல்லது நிறுத்தி வைக்கவோ ஒரு மனு தாக்கல் செய்யும் பட்சத்தில் அதனை மாநில அரசுக்கு தாக்கல் செய்து அரசு, மாநில அரசோ அல்லது மத்திய அரசோ எந்த நீதிமன்றம் தண்டனை விதித்ததோ அந்த நீதிமன்றம் கருத்தினை கேட்டு அந்த மனுவை அனுமதிக்கலாமா வேண்டாம், whether application filed by the convict can be granted or not. The opinion of the court is obtained by the state government, then granted together with reason for, and also forward with the statement of such opinion a certified record of the trial court, such a record of it to exist. So a certified copy of the application and records, copy of records of such records exist, so it will be sent to the court for opinion. And then 432 subclass 3, 432 துணை விதி 3. I will read the subsection 3. If any condition on which sentence has been suspended, a sentence is suspended or remitted with a condition, so the government passed an order to remit or suspend the sentence with the condition order is passed. Upon this condition, you have to obey this condition, failing which suspension or remittance will be cancelled. So condition order will be passed by the government. So it is appropriately not fulfilled. So when condition order imposed by the state government is not fulfilled by the convict, ஒரு தண்டனை பெற்ற நபர் நிபந்தனை அடிப்படையில் தண்டனை குறைக்கவோ நிறுத்தி வைக்கவோ உத்தரவிடுவது அந்த நிபந்தனை அவர் பின்பற்றவில்லை என்றால், fails to fulfill the condition imposed by the state government, the appropriate government may cancel the suspension or remission. So the government is entitled to cancel because he did not obey the condition imposed by the government. Hence, non-obedience of the condition imposed by the government, thereby the government is entitled to cancel the remission or suspension. That is the basic things. So, who is suspended or remitted, and he may be ordered to be arrested and committed to the jail for undergo unexpired period of portion. So, when a condition is imposed for suspension or remission, he is not following the condition, then the government can cancel the suspension and remission, and he will again warrant will be issued and he will be arrested and sent to the jail for undergo the remaining sentences that is the whatever it is. Then condition on which sentence is suspended, remitted, and may be fulfilled. So he obeyed the condition. Subsection 3, he is not obeying, but subsection 4, condition order is obeyed. Then what is the person who is in favor of settlement is suspended and independent or one of his this will. So the condition are suspended, remitted, and they may be one be fulfilled by person in whose sentence is suspended or remitted, and so he is bound to fulfill the condition. That is the basic things. So then there is no need to issue warrant and send him to jail. So that is the basic thing. Then subsection 5, appropriate government may general rule or special rule give direction to the as the suspension of sentence, condition on which petition shall be presented or dealt. So the rules can be made out by the government how to deal with the petition whenever a petition is presented by a convict to suspend the sentence or remit the sentence. What is the procedure to be contemplated while considering the application filed by the convict accused? That is the basic things. ஒரு தண்டனை பெற்ற கைதி ஒரு மனு அரசுக்கு வழங்கி என்னுடைய தண்டனையை நிறுத்தி வையுங்கள் அல்லது குறையுங்கள் என்று ஒரு மனு தாக்கல் செய்தால் அந்த மனுவினை எவ்வாறு என்ன நடைமுறையில் பின்பற்றி முடிவு செய்ய வேண்டும் என்பதற்கு விதிகளை மாநில அரசு விதிகளை வகுக்கலாம். So the government is entitled to frame the rules how to deal with the petition filed by the convict to suspend the sentence or remit the sentence. That is the basic. The rules of the special orders provided that in any case of the sentence other than the sentence of fine, so without fine other than the fine, a male person above the 18 of years. So other than the fine, a male person of 18 of above the age, no such petition by the person sentenced or any entertained unless sentenced is in jail. A person convicted, he can present the application without going inside the jail. Whether he is entitled to file any application under this provision, no. So he should be in jail. A person convicted, if he is a male, but he should be above the age of 18. So these two conditions should be fulfilled. He should be a male, then he should be above the age of 18, and also he should be inside the jail. So these three conditions should be mandatory. It is a mandatory condition. Then only application can be filed before the government to remit or suspend the sentence. So that is the basic things. So whenever a person wants to file an application, he is a male above the age of 18, and also he must be inside the jail. Then on the application filed by the male person above the age is considered by the state government. Then when such a petition is made by person sentenced through the officer in charge of the jail, so he should file the petition through the jailer. So he should file his petition through jailer. So when he is inside the jail, he has to present his application, written application to the jailer. The jailer will send to the government. That is the basic procedure. ஒருவர் தண்டனை அடைந்த கைதி உள்ளே இருக்கும் பொழுது தண்டனை குறைப்பதற்கு அல்லது நிறுத்துவதற்கு மனு தாக்கல் செய்ய வேண்டும் என்றால் அவர் சிறை அதிகாரியிடம் அந்த மனுவினை கொடுத்து அவர் அரசுக்கு அதை பரிந்துரை செய்வார், அனுப்பி வைப்பார். That is when he is inside the bed, where such a petition is made by any other person, that is a relative. Contains the declaration of the person sentenced is in jail. So relative of the convict he is also entitled to file a petition. But the relative should give a should mention that declaration. He should give a declaration that the convict person is inside the jail. That is the mandatory condition. So it can be filed either by the accused himself or his relative, but he should be inside the jail. The relative should give declaration that he is inside the jail. That is the basic things. Then subsection 6. The provision of above section shall apply to any order passed by criminal court under any of this code and any restrict the liberty of anybody imposes any liberty upon or his property. So order passed, whether in any other case, criminal court, apart from conviction, ஒரு குற்றவியல் நடைமுறை நீதிமன்றத்தில் தண்டனை இல்லாமல் வேறு காரணத்திற்காக எந்த நிபந்தனை ஏதாவது ஒரு நபர் மீது ஜெயில் அடைக்கப்பட்டாலோ அல்லது சொத்து மீது நடவடிக்கை எடுக்கப்பட்டாலோ இந்த நடைமுறையை பின்பற்றுவதற்கு அதிகாரம் உண்டு. ஸோ தட் இஸ் தி subsection 6 state that other than the offense any person is kept inside the jail or any person imposes condition is imposed upon the property, then the procedure contemplated this section can be adopted. That is the 432. Then in the section 433 express appropriate government. So according to the 433, who is the appropriate government? In case of sentence of offense against the state, if it is offense of against the central government, suppose a case conviction is made by a court, charge for which is filed by CBI or Delhi Police Authority or central government, by any offense it is tried as an offense against the central government, then the central government is the appropriate authority. So see, a person is convicted for an offense committed by him for which investigation is done by the CBI, then you have to make an application before the central government. That is the example for it, union extensive government. In any other case, state government, other than in any other, for remaining matters, the state government is appropriate as the government. So that is the basic things of the thing. I will give you some of the citation. Conviction, check, dishonor as check, mode of recovery, 431 clearly provides order of pay, compensation, 3% can be recoverable the way if there was a fine. Section 421 CRPC further provides that the mode of recovery of fine and sentence clearly provides that the person can be imprisoned for non-payment of fine. Thus, mode of recovery of fine and compensation on the same footing. So, the compensation and mode of recovery of fine can be done. That is the K.A. Abbas HSA versus Shagu Joseph and others, 2010, 2 Law Weekly Criminal, page 998, Supreme Court. Then, nature, 431, court stipulates that money other than the fine account order passed and shall be recovered as if it was fine. அபராதை தவிர வேறு வகையில் ஏதாவது தொகை நஷ்டஈடு போன்றவற்றை வழங்க சொல்லி உத்தரவிருந்தால் அதை அபராதம் வசூலிப்பது போல் வசூலிக்கலாம். That is the basic things. That is the Vijayan versus Sadanandan K. 2009, 3 CTC, page 786, Supreme Court. Equivalent cited as 2009, 6 Supreme Court cases, page 652. 2009 Criminal Law Journal, page 2957. So, remission of sentence of period which the accused was on bail. If the accused enlarged on bail cannot be granted benefit of period which they were on bail purpose for counting the period of sentence already undergone to apply remission given by the government. So during the he is on bail, that period cannot be considered for remission. That is the basic thing. Joginder Singh versus State of Punjab, 2011, 6, Supreme Court, page 887, and also 2002, 1 CTC, page 55, Supreme Court. Then 433, power to commute the sentence. If appropriate and with the consent of the person sentenced, commute the sentence. ஒரு அந்த கான்விக்டினுடைய சம்மதம் இல்லாமலேயே, so the consent of the convict is not necessary. The government itself can done. Without any consent, the government is entitled to commute the sentence. That is the basic things. So without consent of person, commute sentence of death for any other Indian Penal Code. If a person is sentenced to death, it can be reduced as a life imprisonment by the government itself. The consent of the accused is not necessary. That is the basic things. Then a sentence of imprisonment for life per a term not exceeding 14 years or fine. So a life sentence is imposed, it can be reduced to 14 years or fine. So till his life, a person is imprisoned for life, his age of 20 or 25, whether he should be in throughout life, that can be reduced to 14 years. That is the 25 and 39, he can be reduced at the age of 39 by commuting the sentence of life. 14 years. ஸோ நான் 14 ஆண்டாக குறைக்கலாம். ஆயுள் தண்டனையை 14 ஆண்டுகளாக நீதிமன்றம் அரசாங்கம் குறைக்கலாம். A sentence of rigorous imprisonment may be treated as a simple imprisonment. So a person sentenced to undergo rigorous imprisonment, if any health issues are there, and then it can be converted as a simple imprisonment. That is the basic things. So these are the sentence of imprisonment are fine. If a sentence of simple imprisonment can be altered to as fine alone. That is the basic things. So it can change the sentence of imprisonment. So life sentence can be modified as 14 years. He need not wait for till the last breath of his life. Likewise, a death sentence can be reduced as a life sentence. A sentence of imprisonment can be, a rigorous imprisonment can be converted as a simple imprisonment. Likewise, simple imprisonment can be converted as a fine alone. That is the power given to the state appropriate government. 433. Then 433A, restriction on power of remission and commutation in certain cases. So notwithstanding contained in 432, anything contained in the above section, whatever stated in the 432, commutation whether can be done in all cases. Certain restrictions are there, where a sentence of imprisonment life imposed on a convict person for an offence for death is one of the punishment provided. Sentence of death imprisonment imposed has been convicted for into life imprisonment. Such a person shall not be released unless he has been served the 14 years of imprisonment. Once a death sentence can be modified as life sentence, but he should serve 14 years in the jail, before which he should not be ordered to be released. So then and there, the government is once a sentence is committed or modified to some other form, he should serve the sentence. That is the basic things. So thereupon, the state government is not entitled to commute the sentence. A life sentence, whether 14 years can be reduced, that cannot be done. So the 14-year sentence can be reduced to 10. Death sentence is reduced to life sentence, then after some lapse of years, whether government is entitled to reduce the 14 years to 10 years, that cannot be done. So once death sentence is reduced to life sentence, then he should undergo the entire life 14 years sentence. Then that is the basic thing. So concurrent power of the central government in case of death sentence. So whenever a person sentenced to death, the state government and central government may decide whether his death penalty can be reduced as life. They both central government and state government are having equal power to reduce the death sentence into life sentence. ஒரு மாநில மத்திய அரசுகள் இரண்டுக்கும் ஒரு மரண தண்டனையை ஆயுள் தண்டனையாக மாற்றுவதற்கு இரண்டு அரசுகளுக்கும் சம அளவு அதிகாரம் உண்டு. That is the basic thing. 435. State government to act after consultation with the central government in certain cases. So state government wants to reduce a sentence in certain cases. It has to get the opinion of the central government. That is the 435. When? What is the condition to get a consultation from the central government by the state government? That is the 435. 435 deals with that. State government wants to commute the sentence or remit the sentence. It has to consult the central government. So what is the necessity and upon what circumstances? The power, ஒரு மாநில அரசு ஒரு தண்டனை மாற்றி அமைக்க விரும்பும் பட்சத்தில் அது மத்திய அரசை ஆலோசனை செய்து கீழ்கண்ட சில சமயங்களில் ஆலோசனை செய்து மட்டுமே மாற்றி அமைக்க உத்தரவிட வேண்டும். If powers conferred by the section 432, state government to remit or commute the sentence or in any case where sentence is for offences. So the following offences the state government wants to remit or commit the sentence, then the following convict persons. When a case is investigated by the Delhi Police Special Authority, charges is laid by the Delhi Police. In such a case, person is convicted, then the state government wants to commute the sentence or reduce the sentence, which is investigated by the Delhi Authority, Delhi Police Authority. The state government wants to give some remission. Before giving revision, it should get an opinion of the central government, then only the state government is entitled to reduce or commit the sentence. That is the basic things. Then it is investigated by central act other than this code. So central act, மத்திய சட்டத்தின் கீழ் எந்த புலனாய்வு நடந்தாலும் CBI investigates a case, then in such a case the state government wants to commute or reduce the sentence, it should get opinion from the central government. ஸோ ஒரு மத்திய புலனாய்வு பிரிவு ஆனது ஒரு வழக்கினை விசாரணை செய்யும் பட்சத்தில் அந்த வழக்கில் எதிரி தண்டிக்கப்பட்டால், CBI வழக்கில் எதிரி தண்டிக்கப்பட்டால், அந்த வழக்கின் அந்த எதிரிக்கு ஏதாவது தண்டனை சலுகை வழங்க வேண்டும் என்று மாநில அரசு முடிவு செய்யுமானால் அது மத்திய அரசை கலந்து ஆலோசித்து விட்டு மத்திய அரசின் அனுமதியுடன் தான் செய்ய வேண்டும். மற்ற குற்றங்களை பற்றி கவலையில் CBI ஒரு இன்வெஸ்டிகேட் பண்ணால் டெல்லி போலீஸ் பண்ணாலும் பண்ண வேண்டும். which involved in misappropriation, destruction of the damage of the property of the central government. 406 or 420, whatever the offence is made, but the property offence is done against the central government. Suppose a post office money misappropriated by a postman, however, in the charge it is laid down, then the state government wants to reduce the or commit the sentence of that particular accused, it should get to opinion from the central government. ஒரு மத்திய அரசுக்கு சம்பந்தப்பட்ட தபால் துறையில் ஒருவர் கையாடி விடுகிறார், மத்திய அரசு சொத்தாகிறது. அந்த மாதிரி நபருக்கு, தண்டனை பெற்ற நபர்களுக்கு தண்டனையை குறைக்க வேண்டுமே கூட்ட வேண்டும் என்றால் அந்த மத்திய அரசின் சொத்துக்களை களவாடியதால் அல்லது மிஸ்அப்ராப்ரியேஷன் கையாடல் செய்ததால் அந்த சம்பந்தமான எதிரிகளுக்கு தண்டனை பெற்ற எதிரிகளுக்கு தண்டனை குறைக்க வேண்டுமென்றால் மத்திய அரசின் அனுமதி பெற்று கருத்தினை பெற்றுத்தான் செய்ய வேண்டும். When it is committed by in service of central government, so certain offences, income tax, sale tax and GST and whatever it is, central excise department, railway department, and these are they are the bank employees, central government employees. So offence is committed by central government employee with regard to discharge of his official duty. So a central government employee committed an offence while discharging duty. He is prosecuted and again he is convicted, and the state government want to reduce the sentence or commute the sentence of that central government employee. Then application is made to the state government. The state government should get the opinion from the central government. He is employee of central government. He is convicted. He is filing an application. The state government and desires to reduce or commute the sentence. The opinion of the central government is needed. Then after getting opinion of the central government, then only the state government is entitled to whatever it is shall be done by the state government. So shall not be exercised by state government except after consultation with the central government. These are the so state government wants to exercise the power under this chapter, any of the to commute or reduce the sentence. And with regard to the offence committed, the affairs of the central government or central government employee or investigation done in central government agencies after the conviction, the accused commutation or reduction of sentence can be done by the state government only after consulting with the central government. Opinion of the central government should be obtained. Then no order of suspension, remission, commission of sentence was by sent in relation to the person who has been convicted and some related matter which the executive power of union extends. ஸோ அந்த மத்திய அரசுக்கு தான் அதை எக்ஸிக்யூட்டிவ் பவர், அட்மினிஸ்ட்ரேட்டிவ் பவர் இருக்கும் பட்சம். ஹூ ஹேஸ் பீன் சென்டென்ஸ்ட் செப்பரேட் டைம் இம்ப்ரிஸ்மெண்ட் விச் ஆர் ரன் கன்கரண்ட்லி and shall have the effect on the sentence of such and may be sentenced may be made central government in case offence of such a person to the matter which the executive power of extends. So a person committed an offence against the state and also central. So he is convicted for both. Whether in such a case, so there is offences within the purview of against the central government and also state government. So he is convicted. Whether both offences are convicted by the court, then whether the state government is entitled to remit or commit the sentence, no. So that should not be done because it involved also central government powers within the purview of central government. So with regard to execution of sentence of imprisonment, death, fine or imprisonment, and how to execute the sentence of imprisonment, how to reduce the sentence, how to modify the sentence already passed by the court. These are the provisions are contemplated in the chapter 32 of the Criminal Procedure Code. The chapter 32 deals with it. So these are the fundamentals. So chapter 32 is only relating to the execution, remission, conviction, whatever it is. So that what is the procedure. So with this I conclude my class on this aspect. If you are not subscribing my channel, kindly click the word subscribe. Thank you for watching. If you want to share this to your friends, kindly share it.